Hi guys, and welcome back to my channel. My name is Melissa Siegel. I'm a professor of migration studies, and this is a channel about all things migration. And now today we are going to talk about a key concept in international and refugee law, non-refoulement. The principle of non-refoulement is rooted in several key international instruments that guarantees that no individual, regardless of their migration status, should be sent back to a country where they may face torture, persecution, or other forms of cruel, inhumane, or degrading treatment. The protection applies universally and is central to both refugee law and human rights law. Now, one of the most significant original sources of the concept of non-refoulement is the 1951 Refugee Convention, specifically Article 33, which prohibits states from expelling or returning a refugee to any country where their life or freedom may be threatened based on factors such as race, religion, nationality, membership in a particular social group, or political opinion. So other critical aspects of non-refoulement is the role in the refugee status determination process. So when an individual seeks asylum, states are obliged to carefully assess whether the person qualifies for protection under the Refugee Convention before any decisions regarding removal can be made. In practice, this means that asylum seekers must be allowed to remain in the country where they have applied for protection until a thorough evaluation of their case has been completed. For instance, the importance of this principle is highlighted in the European Union law, where asylum seekers must be permitted to stay in the host country while their application and any appeals are being processed, ensuring that they are not subject to removal during this critical period. This guarantees that their right to appeal is fully respected, in line with both international and EU obligations. Within EU law, specifically Article 21 of the Directive 2011/95, this explicitly codifies protection from refoulement. Nevertheless, despite the theoretical absolute nature that should characterize non-refoulement, this same article also gathers conditions of exceptionality similar to those in Article 33(2) of the 1951 Refugee Convention, which allow for the removal of individuals who pose a threat to security of the host country or who have committed particularly serious crimes. So beyond refugee law, non-refoulement is also enshrined in broader human rights treaties, such as the Convention Against Torture, the International Convention on Civil and Political Rights, the International Convention for the Protection of All Persons from Forced Disappearance, the European Convention on Human Rights, and many others. So therefore, even though this protection was initially developed in relation to the protection of refugees, it applies to all people, not just refugees, making it a critical part of international human rights law. All in all, non-refoulement serves as a cornerstone of international refugee protection and human rights law and enshrines that individuals fleeing persecution or serious harm are not abandoned to their fate by being sent back to dangerous environments. As a result, the principle of non-refoulement is not only about maintaining legal standards, but also about upholding basic human dignity and the right to life. So now, what is problematic, or where do we see problems arise? So specifically when we talk about issues of implementation of this. While the principle of non-refoulement is a cornerstone of international refugee and human rights law, its implementation presents significant challenges, both legally and practically. And I will cover 4 of these key challenges or issues. So the first is that really one of the main issues is the inconsistent interpretation and application of the principle by different national bodies and national authorities. An illustrative example of this is the inconsistency in the case of 2 Peruvian brothers who, in the early 1990s, were denied asylum in Sweden and subsequently issued removal orders. So following this, the brothers pursued separate legal avenues. One filed a claim under the European Convention on Human Rights, arguing that his removal would expose him to a real risk of torture or inhumane treatment, while the other brother logged a claim under the Convention Against Torture on similar grounds. Despite the identical facts in their cases, both faced threats due to their political activism. The ECHR concluded that expelling the first brother would not violate Article 3 of the ECHR, while the Convention Against Torture found that the removal of the second brother would breach the prohibition of refoulement under the Convention Against Torture. So this divergence really highlights the discrepancies in the application of the principle of non-refoulement across different legal instruments due to the nuances inscribed in their different legal instruments. Now, a second issue is the limitations of the Refugee Convention itself. The protection against refoulement under Article 33 of the 1951 Refugee Convention is not absolute. It applies only to those recognized as refugees, and there are exceptions. As has been mentioned, Article 33(2) allows states to refoule individuals if they pose a threat to national security or have committed serious crimes. This introduces a balancing test between the risk of persecution and states' national security concerns, which opens the door for states to manipulate the principle and limit its protections in certain cases. Despite this, some scholars argue that the principle of non-refoulement has acquired a jus cogens status, meaning it has become a norm of customary international law and therefore is binding on all states, regardless of whether they are parties to the Geneva Refugee Convention and its protocols. Nevertheless, others highlight the fact that if non-refoulement were truly a matter of customary norms in international law, that no exceptions would ever be permitted under any circumstance, which contradicts the explicit exemptions allowed under Article 33(2) of the Refugee Convention. Now, a third significant challenge arises from the expansion of exceptions related to terrorism and national security concerns, which have further undermined the principle's absolute nature. In the United States, for example, the broad interpretation of what constitutes a threat to national security or terrorist affiliation has been used to deny asylum to individuals who would otherwise qualify for protection under the 1951 Refugee Convention. Similarly, the concept of safe third countries also raises concerns on the potential refoulement of legitimate refugees due to overly broad or politically motivated exclusions. Originating in the 1970s and 1980s to address refugees in orbit, this concept allows asylum seekers to be returned to a country deemed safe where they could have or should have sought protection. However, the criteria for designating a country as safe are often opaque and subject to political manipulation, leading to inconsistencies and potential risks of refoulement. For instance, national procedures vary widely, and some countries may prioritize immigration control over genuine safety assessments. If you would like to learn more about the concept of safe countries and safe third countries, please see our other video on this concept here, and we'll make sure to link it in the description below. Although the prohibition of refoulement does not preclude removal to a safe third country, the presumption of safety is not automatic and must be evaluated on a case-by-case basis to ensure the individual's safety and access to protection. These issues illustrate how broad exclusions and politicization of the safe third country lists can undermine the integrity of international protection systems, a topic further explored in the previous video on safe third countries on this channel. Lastly, a fourth critical problem is states' practices that are aimed at circumventing their obligations under non-refoulement. Many countries have adopted non-entry policies designed to prevent refugees from ever reaching their jurisdictions, thereby avoiding the need to comply with their non-refoulement obligations. So tactics such as maritime interceptions, visa restrictions, and carrier sanctions have been employed to keep asylum seekers from accessing protection, essentially creating a loophole in the enforcement of non-refoulement. This has become a widespread practice, particularly in Europe and the United States, where interdictions on the high seas and expedited removal procedures limit individuals' ability to present their claims fairly. For more on this concept, see the video on externalization of migration governments, also on this channel. I hope this just gave you a better understanding of the concept of non-refoulement and some of the issues and challenges that we see with the implementation of this concept. If you found this video useful, of course, give it a thumbs up. And if you haven't done so already, please make sure to subscribe to this channel and hit that notification bell so you don't miss any of the videos that we upload on a regular basis on this channel. And I do hope to see you next time. Bye-bye.